The Delhi police today filed its reports against Bharatiya Janata Party MP and benched Wrestling Federation of India chief Brij Bhushan Sharan Singh. Now, two things have happened here. First, the police has submitted a closure report seeking cancellation of the case filed against him under the POCSO Act, which is the Protection of Children from Sexual Offences Act. And the second is that the police has filed a charge sheet in the other FIR for allegedly sexually harassing, molesting, stalking and assaulting women wrestlers. But what happens when a closure report or a charge sheet is filed against an accused? I'll tell you in this video. Now, we know that 2 FIRs were filed against Bhushan on 28th April based on complaints filed by 7 wrestlers, including a minor, who alleged sexual harassment and discrimination during trials and selection for championships after they refused Singh's alleged advances. I had made another video on the allegations in these 2 FIRs and I'm going to add the link to that video to the description of this video. Now, a closure report has been filed in the minor's FIR. A closure report is filed because the principle is that a person accused of an offence does not have to unnecessarily face a trial if there isn't enough evidence against them. That's the basic principle behind allowing the police to file a closure report in any case. So the police can file a report before the magistrate saying that after conducting the investigation against the accused person, no evidence or reasonable grounds for suspicion were found to connect them with the crime. In such a case, if the accused person is in custody, then the police officer in fact can himself release them on certain conditions. This is the report that's called a closure report in common parlance. In this case, the closure report is based upon a revision in the statement given by the minor complainant and her father. The father of the minor wrestler had a fresh statement at Patiala House Court on 5th June in which he retracted the charge of sexual harassment brought against Bhushan. However, just to let you know, it's not necessary that the court always has to accept a closure report. The court also has the power to reject the closure report. If the judge finds that the closure report is defective or perverse, it can in fact also direct further investigation. In exceptional circumstances, a constitutional court like a high court or the Supreme Court can also direct the investigating officer to conduct a fresh investigation altogether. But this happens only in exceptional situations, like I said, like when the investigation is tainted or highly manipulated. So to sum it up, whenever a final report is filed or a closure report is filed, the magistrate has different options. First, he may accept the report and drop the proceedings altogether. Second, he may disagree with the report and take the view that there is sufficient ground for further proceedings and take cognizance of the offence and proceed further. This can be done under Section 190 of the CRPC. Section 190, in very simple terms, you can see the provisions on your screen right now, but to sum it up for you again, provides for powers of a magistrate to take cognizance of offences even in cases where a closure report or a negative report has been filed by the police after investigation. Third, the judge may also direct further investigation to be conducted by the police. This is under Section 156 of the CRPC. But what can the complainant or the aggrieved person do when a closure report is filed? The CRPC has provisions for it. It requires the police to inform the person who filed the complaint in the case whenever they finish their investigation and file such a report in the court. And the complainant or the aggrieved person can then file something called a protest petition. Now, protest petition itself is not defined under the Criminal Procedure Code of the CRPC, which is the rule book for criminal trials in India, but it has evolved through different judgments. In simple words, it is the representation made by the victim or an informant to the court during the police investigation or after the police investigation is completed to object against the police's closure report in a given case. It is filed, like I said, by an aggrieved person or a complainant if they are unhappy with the outcome of the investigation conducted by the police. Now, after a protest petition is filed, the magistrate again has several options. I'm going to list them down for you. They can first accept the final report and reject the protest petition, that is, accept the closure report and reject the protest petition that the aggrieved person or complainant has filed. Second, they can accept the protest petition and reject the closure report and directly take cognizance of the offence under Section 190 of the CRPC and proceed with the trial. 190, I told you earlier, that's the provision that allows the judge to do that, to reject the report as well and proceed on its own knowledge. Third, the judge can also accept the final report but treat the protest petition as a separate complaint. He would then take charge of the complaint and proceed under another provision, which is Section 200 of the CRPC. Again, I know I'm throwing too many provisions at you right now, but I'm going to simplify this for you. This provision allows the magistrate to take cognizance of an offence in a complaint after examining the complainant and their witnesses. So the magistrate can then conduct this further investigation, sort of an independent inquiry into such a complaint. So that's the recourse that's available to the minor victim and her father in this case as well. In case they want to challenge the closure report, they can file a protest petition before the court. Also, depending on what course the court decides to take on the closure report that's been filed before it. Now, this is about the closure report, but on the other hand, if after investigation the police officers find there is sufficient evidence or reasonable grounds against the accused, then they can file a charge sheet under section 190 of the CRPC before the magistrate. This is the same provision but under a different subclause. And this is exactly what has been done on the second FIR filed by the 6 women wrestlers against Bhushan. In this case as well, the court has 3 options again to list them down for you. They can firstly accept the report and take cognizance of the offence, or second, they may disagree with the report, the charge sheet, and drop the proceedings, or third, they may direct further investigation again under CRPC and require the police to make a further report. So those are the options that are available under the law for the judge. But however, a charge sheet is only filed by the police when they usually find sufficient evidence against the accused. So after charge sheet is filed, the court goes on to usually frame charges against the accused, which simply means that they precisely tell the accused what the accusations against them are and what the prosecution intends to prove against them. After the charges are framed, the court begins the trial. Evidence from both sides is heard, witnesses are examined, and the court pronounces its judgment. So now, with these 2 reports being filed, a closure report on one hand in one FIR and a charge sheet in the second FIR in the cases against Bhushan, it is now on the judge to decide what happens next. Thank you so much for watching. This is Apoorva Mandhani for ThePrint. For more such videos, do subscribe to our YouTube channel and follow us on Twitter, Instagram, and Facebook.